And I guess you've been an attorney for BP for what, a number of years?
Yes, sir.
A number of years. A concern we have is that most of the agencies on the siting board have staff, and I guess it's part of the process that they can appoint staff members of their agency to sit in their stead for some of these siting board decisions. Concerns I have is that I'm assuming that you've had access, that you've been in a public service building probably a number of times in the course of those years. Can you give us some idea of how frequently you've been in that? I think your office is what, a couple blocks away from the public service building itself?
I'm really here to talk about.
No. I think that okay. Then consider this as something that hasn't been identified. You mentioned something in your presentation that one of the things you want to do with the scoping is identify issues that haven't been resolved to a point of having. Well, I will identify one, and the fact is, I think the attorneys for BP, I think BP itself, I think all the applicants in this whole process have had access to governmental buildings. I think they've walked in there on a daily basis almost, I would suggest. I come from the standpoint of being a DEC employee, a retired one. I was involved with some stuff when they were siting the Somerset plant out in the other end of Lake Ontario. We had consultants coming into our office all the time when we were going through the review process. So I know that this is happening. The fact is that you're probably BP has probably had a number of meetings with the DEC on permitting issues and that type of thing. You've probably been into the public service office. The point is, municipalities and small towns have not had that access.
I'd point you to the Article 10 process itself, and the public involvement program specifically requires us to engage with all those state agencies and authorities.
I know, but what I'm saying is you've probably done that for years. This question about the Article 10 itself, I'm assuming that you've been engaged with these folks all along, and I'm saying the municipalities haven't. The municipalities haven't had that same access.
Except you just, I don't want to engage in a give and take here, but you just admitted that you're a former DEC employee. You bring whole different breadth of experience and depth of knowledge to the table that I don't have. So, I mean, when you talk about balance of equities, you're actually a very well-informed constituent. And so I think, I mean, this process, again, is set up to allow parties, interested parties, municipalities, and people from the public to engage. I'm not here to talk about who has better access or better lawyers. This is about how the process works and where in the process you have an opportunity to engage with BP, with affected agencies, with providing comment on the preliminary scoping statement or the application itself.
Well, I hope we can. I mean, this has to do with the game and the table being tilted. I mean, small municipalities have lost already home rule. But this is a case that you've got people sitting on the siting board who have staffs that have interacted with you, that have interacted with the applicants and everything else, that have developed relationships. They know these people. And you're dealing with a small municipality sitting right here. We haven't had that access. We haven't walked through those halls and rubbed elbows. We haven't gone out to lunch with some of these people and what have you and developed relationships. And that's going to make a difference when a decision has to be made. And all I'm saying is, please identify that as an issue. Because it hasn't been listed, I saw it nowhere with respect to the Article 10 law, the rules that were promulgated or anything else.
I appreciate your comment.